funding of political parties. Under the existing law, for transparency of funding, political parties are required to submit their contribution reports in excess of 20,000 from any person. However, there is no such transparency requirement either regarding source of funding or dispersal of funds to political parties through electoral trusts. Therefore, there is a legal vacuum in respect of disclosure of contribution reports by electoral trusts. In exercise of the plenary powers vested in it by virtue of Article 324 and all other powers enabling in this behalf, the Commission hereby issues the following instructions. Electoral trusts are required to submit an annual report of contributions to the Commission before the due date of filing of the income tax return. The report shall be in the enclosed format. The report shall contain details of contributions received from any person or entity, details of all donations given to political parties in a financial year as per the format, and the format specifies the period and the specificity. The annual report shall be verified, signed by the person authorized, and a copy of the. And if your lordships was speaking of the Satya Electoral Trust ballots, that the list of approved trusts was there, and then, my lords, the abstract of donations, details of the contributions, and Part C, name of the political party, PAN, amount distributed, date, and mode. So it's not as if, even under the existing law, the opacity cannot be reduced. I'm grateful.
Thank you, Mr. Ide. Yes.
So, comment is there, page 7305, volume 4.
Volume 4, page 7305. Thank you. See, maybe we'll put that. Go.
Yes. My lords, I appear on behalf of Dalit Panthers Party, my lords. My written submissions are at page 182 of volume 1. What you may kindly have it. Page 182 of volume 1. And my IA number is 156371 of 22. 156371 of 22 minutes. 182 minutes.
Yes.
My lords, my submission is threefold. My lords, the first submission is, my lords, we represent a political party, which, my lords, in fact, the political party for a change is on the side of the petitioners, challenging the scheme, the electoral scheme, or the secret bond, as we call it from our side. Now, my lords, the issue here is, as a political party which espouses the cause of Dalits and other marginalized people, my lords, this scheme is in such a way it's structured that it has a desperate and a more severe effect on us than other political parties. So that way, my lords, there is a very hostile discrimination as far as our parties are concerned, which expose the cause of these marginalized sections for two reasons. And this court has held, my lord, this is what precisely has to be avoided in any scheme or in any law.
Yes.
What is the first point is, if your lordship would see, my lords, clause 3.3 of the scheme, if I may call it as clause 3.3 or rule 3.3 of the scheme, there is a cap of 1% of the electorate. It says, my lords, only the political parties registered under section 29A of the Representation of People Act and secured not less than 1% of the votes polled in the last general election to the House of the People or the Legislative Assembly, as the case may be, shall be eligible to receive the bond. Well, the point here is, when you make a discrimination between 1% and the other 99%, there is absolutely no rational nexus. Because
a political party should have polled at least 1% of the votes in the election. Tomorrow you may have a 2% party and claim donation.
well, this is our case, there is a barrier to entry. And nascent political parties, my lords, in a free and fair election, the receipt of political donations cannot be cut. My lords, for example, I start a political party.
You can receive donations, but you can't have electoral bonds coming.
Well,
And the exemption.
That's precisely the, my lord, that is where I stand at disadvantages. When people don't come out, my lords, to give monies to political parties on the basis of their ideology, people will definitely not come to me, my lords, on the basis of my ideology. Because they want to be anonymous. The very purpose of what the state says today is anonymity is given for the purpose of protecting the people who give these bonds. And when that anonymity is taken away, my lords, my point is that it affects me directly. That same anonymity would apply to me.
Because, even other political parties, it's not that, only a political party like yours espouses the cause of the marginalized sections.
Not really.
There would be mainstream political parties which equally espouse the cause of the marginalized groups because they depend upon them as their constituents.
My lords, we are next. The point is, my lords, that where anonymity is given to all political parties, I should be given the same anonymity in the sense that I am also a political party registered under the Representation of People Act. Why not 5%? Why not 10%? There is absolutely no empirical data to suggest why you have protected under 1%. The whole point is, my lords, when anonymity is given to all political parties under a statutory enactment,
But then you also have threshold requirements for allotment of an election symbol.
it should be supported by data, my lords. There's absolutely no data. For example, it's 0.99%.
That you made your point. What's the next point now?
That's one point. My lords, the second issue, my lords, is that if your lordship may kindly see, the issuing at Rule 3.6, my lords. Rule 3.6. The bond shall be issued to the buyer on a refundable basis.
There's no rule 3.6. No para 3.6.
My lords, it's sorry, my lords, 8.2, my lords. I'm sorry. Yes, it is 6.66, my lords. It's 6.6.
No, there is no 6.6.
Six.
You may be referring to 7.6.
It is 7.6.
Volume
Yes,
4, page
it's 7.6.
119.
Yes, my lord, 7.6. The bond shall be issued to the buyer on a non-refundable basis. These are irrevocable bonds. So even by lords, even by mistake, the whole point is read with 10. 10 talks about issuing officers and commission payable. No commission, brokerage or any other charges for issue of the bond shall be payable by the buyer against purchaser of the bond. Now, this is taxpayers' money. For example, my lords, if myself or anybody else here wants to buy even a demand draft or a promise or anything else, my lords, there is a charge which is borne by the customer. Here, the customer bears the charges of a note which is being given actually free of cost. So, my lords, these are,
I don't think we need to labor on these points.
these are all, my lords, things which have been tightened
These
to
lie in
ensure
the realm of
facilitate.
policy. These lie in the realm of policy. These are not the best points. I mean, let's
My lords,
not.
your lordship may kindly see, my
We are
lords.
missing the wood for the trees
My
by
lords, if your lordship may kindly see at page 1115, my lords, volume 4.
substantive arguments have been made.
1115, my lords, your lordship may kindly
Dilute the
see.
impact of those arguments by going into these.
1113, my lords, your lordship may kindly see 1113. 1113 for disparate impact. 1113, volume 4. My lords, here your lordship is under 182, it is the corporate boards which take a decision. And as well as we are concerned, my lords, the empirical data suggests that we control only 3% of the boards in India. That is in respect of 1,000 top companies which are registered in the stock exchange, Bombay Stock Exchange, as well as the National Stock Exchange, where the market capitalization is 1/4. The Dalits and the other marginalized
We're not
have
belittling-
only
we're not-
3%.
We are not belittling your grievance, but your grievance is a wider systemic grievance, which is not particularly related to electoral bond.
My lords,
So your grievance really has to be in the form of another petition. which challenges broader aspects of our election law, which have a disparate impact on parties espousing the cause of the marginalized. But by really conflating that grievance with the challenge to the electoral bond, we are really losing sight of the specific challenge in relation to the electoral bonds. We may want to come forth with a petition, a broader petition challenging those provisions of the election law, which may have possibly a disparate impact on parties, say, espousing the cause of the Bahujan parties. We're not at all belittling that, but we're just trying to say that let's not lose the focus of this.
This aggravates the inequalities, my lords. My point is,
All right.
schemes after schemes like this. My lords, today, my lords, my position is,
problem
if I have a
that,
nascent party,
we don't want to say in this petition, assuming that the others are right, that you have not made out your cause, because that may lead to your cause in that sense being impacted by us ruling on this in a petition where, we don't have the sufficient data. We
then
don't
your lordship may kindly
this
see.
overview of our election law. So you are raising a point relating to the marginalized groups, but please keep your powder dry for a substantive challenge in a separate petition. That's what we are trying to just sort of without advising you, but
I
I
follow.
don't want to lose the impact of what you are saying in a more specific challenge. This is a very niche challenge in that sense. Very important challenge, but a niche challenge.
Then my ground on 19-1A, my lords, is slightly different. If your lordship may kindly look at my notes, my lords, my 19-1A challenge is that at page 180, at page 187, my lords, that the right to know rival political parties' funding sources is also a part of a political party's right here. My lords, one is for the voter to know. Because one is for the voter to know as to who is funding whom, as a right of information.
Republican Party is there.
Who bankrolls the rival parties? Well, the position here is, your lordship may kindly see, visualize the position that our parties are in at this stage. Now, bigger parties, because of the money and power play minutes, become bigger and bigger. We become smaller and smaller. There are barriers at the
That's
entry.
not an issue here.
My lords, that's precisely, my lords. Therefore, at least on 19-1A.
Totally going away from the main issue.
My lords, on 19-1A, my lords, in which case, my lords, I'm not pressing that point, at least on 19-1A, the political parties' rights to know rival political parties' funding is.
So, the problem is that you are an intervener. You have not filed a substantive petition. Therefore, we can't strike it down on the ground which you are asserting. You can only support the cause of the petitioner in the main petition.
This is apart from, my lords.
So therefore, you may want to perhaps reassess your position, come to the court or an appropriate high court and challenge specific provisions of the law, election law, which according to you have a disparate impact on the parties which are representing the Bahujan causes. I mean, we're not at all saying that you're not right on your broader grievance. That will have to be examined by a constitutional court. But you may want to perhaps frame it very differently. Why get into it here as an intervener without adequate data, without adequate challenges to other provisions of the law?
That's apart from, well, it's in which case, well, there's the other point on 19-1A.
We will not say anything which will affect your cause. Please rest assured. But we are also trying to tell you that perhaps
Your lordship may kindly, then lordship may kindly say that these will leave another day for this cause to be agitated. Well, it's not that your lordship has read it. No, my lords, the point is, my lords.
Can never affect your rights.
No, my lords, the point is, at least then, my lords, under 19-1A, my lords, I should at least know the critiques of these parties, as far as who is bankrolling. That right to information about political parties being funded.
That Mr. Bhushan argued, Mr. Sibil argued, everybody has argued that. That is no difficulty. Now that has been argued. That point you join with the others.
Yes, apart from, my lords, adopting all this one, my lords, the thing is, just one paragraph of the
I think we'll now conclude
well, it's only one paragraph of the judgment, my lords, and then I'll leave it to your lord.
One paragraph of the?
My lords, page 1804, my lords.
One para of what are you reading?
My lord, 4204 of Kanwarlal Gupta, my lord, Justice Bhagwati speaking, as far as these parties regarding elections and the expenditure and what are the other parties' role. Just 10 lines on that.
Kanwarlal has been cited yesterday.
This one paragraph have not been cited. 10 lines, 2 minutes.
Right.
Your lord, may kindly see me. This is, my lords, 1975 3 SCC 696 at page, my lords, I am reading 4204,
Volume.
volume 4, my lords.
Volume 5, no? Page?
Volume 5, my lords, sorry, I'm volume 5.
Go to.
Volume 5, my lords, 4204. That's 10 lines from top. Or 10 lines from bottom, my lords. The object of the provision, your lordship, 10 lines from bottom.
Yes.
The object of the provision limiting
The expenditure is twofold.
yes, ma'am. It's what not. This is what my mind, this one. Lordship, may I have a look at it? Sorry, my lords, extremely sorry. Yeah, the object of the
But
provision
I-
limiting the amount far in excess of the limit. The object of the provision limiting the
Already seen
expenditure is
it. Yes, you
twofold.
got the point.
That's
That's
precisely
the-
what. So this directly impacts us, my lords, in a way,
Thank
therefore,
you.
my lord, that
Thank you
would be
so much.
considered.
Thank you. Mr. Attention.
For one division of.
Shall I make one short submission?
Mr.
I
Raj,
won't be,
now
I won't be making an,
get to the Attorney General's arguments now. Everybody can supplement what they want to say in a small note or something. You have given your note, Mr. Kalishwaram Raj?
yes, I have given it, no?
Get your
I
note.
have given it, yes.
Yes, Mr. Attention.
We have a division of labor.
Yes.
So on the contours of the scheme, the learned solicitor will advance certain submission. For a larger questions of 19, the connection, confidence, etc. That's how we have proposed to divide our labor. So let the solicitor begin on this preliminary submission.
May it please, Your Lordships. Lord, at the outset, Lord, as my Lord, the Chief Justice and the bench yesterday I'm sorry, I thought Your Lordships are rising. Lord, no, somebody came, so I thought Your Lordships are rising.
Start afresh at 2:00.
I can start at 2, my Lord. It's
Just one thing.
You see, there's one larger issue which we are not really examining, that is of election funding, because that's the second issue which arises, but it dovetails into this issue is with regard to the corporate funding. And whether it should be open, transparent, or whether it should be. Other issue which arises is they have referred to the kickbacks and the bribes and other things, or quid pro quo. Now, there can be various terms used for that. We like the election commission if they are aware of the total financing which is required for each general election or for the state elections. On an average, state elections will be an average, an amount which is collected and used through these bonds. The issue which may come up is, because we have this opacity with regard to who's funding, etc., then how, if there is any quid pro quo, how does anybody establish it?
we have an answer, first of all.
That-
I'll answer that, but please, my Lord, bear one thing in mind. Please, for the time being, for appreciating my arguments, remove the two expressions repeatedly used, anonymity and opacity. It is a restricted, limited confidentiality which can be, my Lord, opened and the veil can be lifted by judicial direction. I'll point that out.
Thanks. We'll resume after lunch.